Jake used to run Duke's Firearm Law Center, for anyone who isn't aware of that. But now he's a full-time professor and is doing his own research as well. Published you published a revised paper that included some new estimates of the effects of Bruin. Can you just tell us a little bit about the top line results of that?
Yeah, absolutely. So the paper is kind of a broader discussion about Bruin, and in the revisions that I just did, I included this analysis that I'd done of the 8 months following the Bruin decision in federal court. And it's kind of the top line numbers were that we were seeing a lot more cases struck down in the immediate aftermath of Bruin than we did in the aftermath of Heller. So I have the numbers right here. So there were, out of 174 total federal court decisions that were issued in that 8 months, there were 12 civil cases in which a court found at least one of the claims prevailed in the case that the statute or government action violated the Second Amendment, 9 in criminal cases, and for an overall 21 out of those 174 decisions for a success rate of about 12% in the first 8 months in total decisions.
Right. Which might not sound like a lot.
By claims.
Right. That might not sound a lot to the average person listening, but how does that compare to after Heller?
Right. So it might not sound a lot in the abstract, but if you remove cases that were challenging, say, the federal law that bars those with felony convictions from possessing firearms, it shoots up dramatically. So for the civil cases alone, the success rate is 31%. And I don't recall off the top of my head what the civil success rate was after Heller. But in the 8 years after Heller, all claims had something like a 9% success rate, including those ones with the felony prohibitions. And so a 31% success rate, 1 in 3 of these lawsuits are having at least one claim prevail in the civil lawsuits where someone's challenging it not as a result of a criminal conviction, is a pretty high success rate overall, and particularly in the 8 months that we've seen since the Bruin decision.
Yeah, it's a dramatic difference. And I think in your analysis, you found there were 0 cases in the immediate aftermath of Heller that first year.
That's right. Yeah. Relying on this a study from the 8 years in the first year, the first 6 months after Heller, no challenges were successful out of 70 different claims.
Right. Yeah. And in that same paper, there's from 2 other professors, right? Eric Rubin.
Yes. Joseph Luckner.
Yes. And so they did an analysis of Heller several years later to see the effects of that law. And so that matches up against your analysis, which shows a pretty dramatic difference. I mean, I think it took 4 years for there to be 30 plus claims that were successful, Second Amendment claims after Heller. And well, I mean, that also includes the 2 years after McDonald.
Yes, exactly. Yeah. 4 years. Yeah. Roughly 4 years to see the same type of lower courts striking down laws we've seen in 8 months since Bruin.
Yeah. And we'll get into some of the, why this is and talk about some of, your thoughts on Bruin and some of, and these effects, but let's just get into some of the more the details of the specifics about these challenges that we've seen and which ones have been successful and which ones haven't been as successful yet. Because you did a detailed breakdown of this in your paper, which people, by the way, can read. And I recommend, people read your paper and all. It's a good resource for this, and it's good to have those differing points of view. I know sometimes on this podcast it can be people from a lot of the pro-gun point of view more explicitly, and so that's why we like to have people on who are more, in your case, you're more critical of the Bruin ruling. Not to say that you're anti-gun or anything, but you come from a different perspective than, for instance, Costas Morris, who we've had on a number of times, who is a pro-gun litigator. So it's good to have that sort of perspective balance out there so you can understand where everyone's coming from. But your paper details these specific challenges and how they perform. Can you give us a breakdown of that?
Yeah. So if you look at the challenges, and I should say one kind of big caveat at the beginning is I only looked at federal court decisions. So there are some state court decisions. There's some state court challenges to state convictions. There are some state civil challenges. I only looked at federal court decisions. And I only looked at the ones that were uploaded to the Westlaw database, which is one of the main databases for uploading, for when courts upload their decisions. So there might be decisions that were issued in the 8 months that weren't there, but that's kind of one big kind of caveat when I talk about these. And I'll say one other thing, which is that I just did a blog post on the Duke Firearms Law blog where I linked to the spreadsheet that I used. So if folks want to look at that spreadsheet, they might say, oh, you should classify this case differently. That's fine. So I kind of disclose the ways. But yours
is it's still the most comprehensive. I'll say that. Like, I don't think I've seen any other analysis attempt to put numbers to these things yet. So it's very valuable.
Thank you. Yes. So hopefully the spreadsheet's there. If people want to classify differently, they can. But when I looked at the cases and I grouped them by types of claims that were raised, you can see there's certain types of claims that are finding more success than others. So New York and New Jersey changed the private property default rule, which is the background norm had been prior to these laws that you are allowed to carry on private property unless the owner objects. And both laws switched the default and said you're not allowed to carry on private property unless the owner gives their consent. And there's been, I'm counting 5 different challenges to those types of laws, in which courts have said that's an unconstitutional thing to do. So those are 5 for 5 success rate.
100%. Yeah.
And then similarly with some of the changes in state licensing laws post-Bruen, so the states that changed their laws to comply with eliminating the may issue requirement, but then adding or specifying their good moral character or their training requirements differently, there have been, at least within some categories of those claims, courts have said that those licensing revisions have been unconstitutional. So I classify those as 3 out of 3 because in the classification of licensing laws, there's been success on those. And then kind of one that's a little bit more broad ranging is to sensitive place laws. So some of these are to new designations of states that have added places to the set of places where a person cannot carry guns. Some of them are to old places and to appeals from criminal convictions from those. But those have had a more than 50% success rate. So I count 13 claims in there, and I think that means 7 of them have been successful. And that's not including kind of every specific designation. It's not breaking it down separately into zoos and playgrounds and mental health facilities. But as a set of claims about sensitive places, about 7 out of 13 of those have been successful. So those have been kind of the buckets of the most successful types of claims. But there are, in almost all categories, and excluding mostly just the criminal convictions, there have been some successes in most categories of gun laws that I've charted.